Should we?
Good
Should,
evening, ma'am.
good evening. Should we wait or should we start off? Because only I could see only 18 members joining. The strength, I believe, uh, we'll wait for a few minutes.
Yes, ma'am.
So the strength as per the list that is given to me, 32 participants should be there.
Yes, ma'am.
We'll wait up to the intent. We'll wait for rest of the people to join, but not invariably. I mean, not infinitely. Infinitely, we'll say another 5-7 minutes. We'll wait and then we can start up. Slowly, everyone is joining.
Yeah, that's fine, ma'am.
How about the other classes and all, which are from starting from 4 o'clock onwards?
Today we got the schedule, ma'am.
I know.
This is the first class we are attending today also.
ठीक है. So they have just given the timetable and they are ready to follow that, isn't it?
Yes, ma'am.
आज ही बना है शायद.
Circulated after 6:30.
हाँ, आज ही बना है शायद. कल से होगा आपका क्लासेस.
जी, ma'am.
And S1P1 is common. Somebody gave message that it's a different syllabus. How come that I am from a different stream? Like that they are giving messages. But you can understand that S1P1 for all the PG diplomas is common. So that's the reason I am combinedly taking for all of you.
Okay.
The rest of the syllabus and all, you have to ask the concerned, faculty, program coordinators.
There is another faculty member assigned to that, ma'am.
हाँ ठीक है, उनसे पूछ लेना अब क्या है सिलेबस वगैरह के, कौन सा पेपर्स रहेगा उसमें, कौन सा थियरी होगा, कौन सा प्रैक्टिकल होगा. आई थिंक दे विल बी इन अ बेटर पोजीशन टू आंसर दोज क्वेरीज.
Yes, ma'am. Theory paper तो दो ही है, बेसिक्स ऑफ क्राइम एविडेंस लॉ एंड इंट्रोडक्शन टू फॉरेंसिक डॉक्यूमेंटेशन एग्जामिनेशन.
हाँ, डॉक्यूमेंट के लिए अलग होगा, फिंगरप्रिंट्स एंड ऑल
वो अलग है.
हाँ, they are all different. Second paper onward they will be different. For SEM 2 and SEM 1 also they will be different. So वैसा तो I think if you can put up the request in WhatsApp group, they will provide you, I think.
They have already assigned the faculty, ma'am. When faculty joins, then we can ask them.
That's what I'm saying.
The only paper where we have slight confusion is that assignment, seminar and library. No professor has been assigned to that till now. So
Okay.
we need to understand what is that about.
See, assignment and all, as we also have run the courses, I feel, some question bank will be given to you, because there is a TA1, TA2 exams. Two types of exams are there. So we normally for TA1 we try to give multiple choice type of questions, and my style of doing it is, I'll generate a question bank. I normally generate a question bank based on the syllabus, taking each word from the syllabus and trying to prepare some 25 questions for each category. So I'll prepare a question bank, and then same questions in permutation combination will be given, irrespective of who the paper setter is. So that way, that is my style of doing. I can't tell about others, but for my regular PG students, which normally when I used to run those courses, that is the strategy I was following. And mini projects and all, I used to tell them in advance that you either select, or if you want me to select and give also, I said there is no problem, because simultaneously that work should also progress, isn't it? And for physical thing, somebody has to. Yes.
there are two professors assigned for minor projects and field visit and crime scene visit.
Okay.
So I'm sure they will take care of it.
Because this is online and all, field visit and all, unless somebody goes physically and all, it may not be possible. No, I don't know how they are going to. For our center, earlier what we did is for practical and exam also, 1 week or 10 days advance we used to call them. And they used to come and then complete the practical part of it also and write the exam and go away once for all. Because people who are far away, like Kerala and all, it will be difficult for them to book tickets and then.
I think same thing will happen here also. Practical exams and other exams, there is a personal attendance is must.
No, anyway for semester. Anyway for semester end exam you have to come physically. So you can as well come little in advance. That is a month, a week or so in advance, 10 days in advance. So that in one go you can complete the practical component. And anyway ऑनलाइन क्लासेस तो चलते रहेगा वैसा तो उसी में डिस्कस कर लेना माइनर प्रोजेक्ट्स के लिए क्या क्या होगा वैसा तो आई थिंक दैट वे वी कैन अवॉइड कमिंग मल्टीपल टाइम्स
That's right. We are close to the center. I am in Delhi only.
Oh, no issue then.
Is also in Delhi, so so there should not be any problem.
वो तो है
Ma'am, you are logged in twice.
Yes. What happened?
You are logged in twice.
नहीं हमारा मोबाइल से चल रहा एडमिट आ रहा ना इसीलिए एडमिट के लिए आई हैव एम्प्लॉयड माय हस्बैंड ही इज डूइंग एडमिट पार्ट ऑफ इट सो आई एम trying to do it from the laptop because I told you already there are issues of connectivity, clarity, resolution and all. Everything is an issue. I am old, my system is also old, so you have to bear with me for some time. तो अभी आपके लिए खरीदना है एक नया खरीदना पड़ रहा हमको लैपटॉप तो टिल सच टाइम यू टू बेयर मैंने वो तो हमारा तनख्वाह ले रहे ना जो जिम्मेदारी बनता है
Ma'am, I actually had a question. If you
please go ahead and ask the question.
Yeah.
Who is that? You can identify yourself. I'm
DNA forensics, right?
क्या है?
Sorry.
Tell me. I couldn't get you.
I am enrolled in PG diploma in DNA forensics.
ठीक है. You are allotted to which center? Campus?
Pune.
Pune. हाँ ठीक है. Then what is the issue?
Yeah. I just wanted to ask about the syllabus, right? So as you mentioned on the text that the first semester is going to be common for all of us, right?
Yes. And they have not yet put up the, they only for the documents and crime scene management, they have displayed the timetable. Similarly for other courses also, they may be shortly displaying the timetables. Once that is done, I think we can always, when to come and then when I will be conducting TA1, TA2 and all, that will be known from the timetable only. Just we'll wait for one more day and let us see.
Now, okay. For semester 1 it's going to be same, right? So we have to attend all these lectures that are being conducted, right?
No,
the syllabus is not same for DNA and for DSC.
I know. That's what I am saying. Timetables are different.
Paper 1 is common.
Only paper 1 is common. Rest of the papers will differ. For PG.
Only paper 1 is common.
Only that is common. Rest of the papers, whether it is semester 1 or semester 2, are going to be entirely different. So we will start off the class.
Can you repeat, please? Which one is common?
Paper 1 is common.
Only paper 1.
Yes.
Yeah.
Okay, so this one I should be here, right, for this paper?
S1 P1 is common for all the PG diploma students. That's what I am saying.
Okay.
And
And
that.
ma'am, also I just had a question about field work and everything that's been mentioned.
Yes.
How is that going to be handled?
We'll discuss that. Whenever we find time, we'll discuss that. Need not worry at all about as far as the diploma course are concerned. Pune, I can give assurance. S1 P1, I'll take care of everything. Don't bother. just don't bother. I'll just let you know when certain thing is going to happen and how to go about it and all. Just I'll leave it to me. I'll do the thing. Okay?
Okay. So ma'am, for now, unless they release the other syllabus, only the paper one's going to be conducted for the lectures?
A paper 2 also they have to take care. I think I'm just yet to see the timetable in detail. Just now I got the timetable, I could see it. For DNA they have not given. DNA they have not given. Only for crime scene I think, and documents only these two things timetable has been prepared. So let us hope that in a day or two they will release that timetable also. Once that is done, we can go ahead and discuss other things. Right? So I think time is up. We will start now. Now last class, if you remember, there is we have discussed a bird's eye view about how the paper is all about, how many units are there, and what is the composition of each unit, and what titles and all that we have already discussed. Now coming to the proper, now we'll go by unit by unit, and then we'll try to understand through the PowerPoint, because most of you should also have some notes to follow. So that is the reason I thought PowerPoint I think is also been shared already, so it should be very easy for you to follow, and in case if you get stuck at one point, you are at liberty to ask me, stop me at any point of time, and then get your queries clarified. So now we know that there are different definitions that are given, and more so crime, and then what is crime is all about, and then is it an act or it doesn't involve any act, only mental thinking is enough, or should it culminate in an act and all. I mean, the crime as such has got different connotations, and it has got different definitions as given by criminologists all over, and let us not bother about the definition given by each scientist, but let us only try to restrict ourselves just to know what is the essence of all the definitions. Now a positive or negative act, that means commission and omission. When I say positive act, commission, and when I say negative act, that is omitted. An act which the law says prohibited, an act which is prohibited by law is, it should not be done. And an act, in the act, if it says that it has to be done and somebody is deliberately omitting it, that also amounts to. So in the definition of the act, omission is also there. Commission also includes omission, is what you need to understand. And what is that act? As I said, in penal law, the violation of it should be there. An act which is in violation of penal law, because penal law is a law which defines, as being a substantive law, it defines your rights, duties, liabilities. And if somebody's right is being violated or infringed upon, then it should have a remedy, isn't it? If there is no remedy, and if somebody's rights are constantly being violated or constantly being infringed, then the society is going to lose confidence in the entire system. So an offense against the state injurious to the public. That is the reason where, compared to a civil wrong and then criminal wrong, criminal wrong is otherwise known as the crime, is viewed very serious when compared to the civil wrong. The reason is this particular right, the crime is against, the offense is against the state, because state is not a single individual, it is being represented by a group of individuals who are living in a particular territory, bound by a territory, and these people are law abiding, they are living in society for the purpose of maintaining some peace and order, and then peace will be at stake if there is anarchy, if there is no rule, isn't it? So whenever we talk of offense, we always mean the state, public at large, or otherwise we say injuries to the public. What do we mean by that? The harm is to the entire public. That means we say that it is public at large. So that is the reason why whenever we quote or cite a case, we say against the state. So and so accused versus the state. This is how it will be represented. And punishment in any criminal proceedings, unlike civil proceedings, this is always the proceedings will end either in conviction, where punishment is levied to the person who is accused of that particular crime, or it can be a forfeiture of property, or he will be put behind bars, imprisonment according to the nature of the crime that he is committing. There will be a punishment, gradation of punishment definitely will be there about it. And there is a court, and there the evidences that are adduced by both the parties, namely the prosecution as well as the defense, will be weighed upon, and there are relevant facts and fact in issue, and which are relevant facts, which are fact in issue, and which facts are admitted and which are not admitted. It is clearly laid down in the Evidence Act. So this is, I mean, every crime will have a punishment. I mean, the wrongdoer definitely has to be booked, and he should be put behind bars, or depending upon the case, he can be levied some punishment, some fine, and forfeiture. So it all again depends. I mean, definitions are very much given in the Indian Penal Code, and then which right is violated. Is it an offence against the property? Is it an offence against the body? Or is some document purported to be in question? So all these things depend upon what is the subject matter. We can again divide the cases, and then criminal proceedings will happen, and then if the man is found guilty, of course there is a punishment accordingly. Then, now when we talk of punishments, as I told you, ultimate punishment will be the death, the capital punishment as we call. And we also know that there are a lot of cases, the Supreme Court guidelines, and then only in rarest of the rare cases, this kind of capital punishment or death penalty is awarded to the accused. But otherwise, this also has to be confirmed by the higher court. Those session courts are also have the power of awarding the death penalty, but then it has to get the concurrent agreement from the approval from the higher court. And of course, if President can give the amnesty and all, I mean, he can pray for that, and it again discretion of the President and all, or the governor, whatever is that particular thing will be there. So that is about the death penalty or the death punishment. And of course imprisonment, you know that imprisonment is also a kind of a punishment that can be given to the accused, and then for how many years, depending upon the seriousness of the crime. It may be 10 years, it may be 7 years, it may be 2 years. So according to the definition that is given under the IPC, it has been well drafted and all, you know, there are definitions that are given. Each particular crime has got a definite definition, and then in some classes are exclusively punishment classes, sections, and some have penal section separate, and then the punishment section separate. So when we deal, IPC will deal in detail about these things, but then there are sections which specify, for example, murder. If some crime has to be recognized as murder, what should be the ingredients, what should be the essential points that one has to consider in order to name that particular offense as murder. So that kind of a definition is given, and as I told you, not all sections are penal sections. So some sections exclusively deal with the definition of the crime, and some other sections exclusively deal with the punishment that can be given. And some other mixed kind of sections are there where definition, that is the penal provision, and also the definition part are combined in a single section. So it is that way it has been drafted. Now imprisonment, of course, fine and forfeiture of the property, because the most important thing for any human being is life. You know, when life is at jeopardy, all your properties, we don't care, a number of houses we have or number of properties we have, they do not actually matter for us when our lives when the life itself is at stake and all. So second thing that we give a lot of importance is our property. So especially when we deal with the serious crimes like narcotic drugs and Psychotropic Substance Act, there you see that ill-gotten money, normally people would like to invest in acquiring immovable properties and mobile properties. So if the investigator can prove that whatever property that he is acquiring, they are all ill-gotten, and the means of getting them is through an illegal means or illegal way, then such properties can be forfeited, and they can go to the government account. So removal from office, of course, is when we talk of disciplinary actions and all, they are minor punishments, I should say. Removal from the office, some suspension, and then these are minor things, and they will not normally come under the definition of punishment under criminal law, but then that is short of criminal punishment. And when we deal with service matters and all, removal from the office or suspension, these matter a lot. And disqualification to hold and enjoy any office, honor, trust or profit in the state. And community service, of course, we see in some temples and religious institutions, this kind of community service is also a part of the punishment. And of course, plea bargaining, see what is, can you reduce the punishment and all. There is also a concept called plea bargaining. So these are different categories of punishment one can think of depending upon the seriousness of the crime. So now what is very important for us is to know the definition of crime and what essential elements are composed in a particular crime. So there are mainly two elements. Now the two elements are, the first being the crime is the human being. The first element in crime is the human being. That means if animal does some wrong, we are not going to punish the animal. We should have a human being who should be committing some crime, and there should be some consequence out of that particular act, and then he must be using some kind of a weapon or some kind of an object to commit that particular crime. So these are some essential elements, but out of those many factors or elements that we have enlisted, there are two very important elements that compose the crime. Now that is called, there is a Latin maxim, you have to understand it, you have to by heart it, and then you have to reproduce that in the exam, because in law mostly maxims are important and citations. So whenever there is a maxim, you have to just understand it, and you should have your own shortcuts to remember it, and it will be always good if you want to score more in especially law subject. You have to quote these maxims. There are very few maxims, either of Greek or Latin origin, so you need to understand it in your own way, how you can remember, look out from shortcuts, and you have to somehow remember it. So actus means there is some logic, some act must be there, non-facet, and re nisi mensitiria. Mensitiria is called mensiria in short. So this is a Latin maxim which says that second element of the crime, and it includes the mental element. Mensiria means actus is act, and mensiria is the mindset or the mental element. This is how you have to understand. And when only a mental status is there, some ill feeling is there in my mind, I wanted to take revenge, I am just planning, all my thoughts are thought process is going towards that, and then nobody can understand what is going in my mind, isn't it? So it has to culminate in an action. So mere thought will not help. If you want to punish somebody, you have to establish both these facts, that there is an actus, and out of that act there is a consequence which is evil in nature, and this particular act should also be it should be punishable act. I mean, not every act is punishable, but law specifically defines and specifies in various sections in various acts which act is going to be punishable and which mental thought, if it is culminating in an actionable outcome, then that is punishable. That's what you need to understand. Actus non facit riem nisi mensi tiria. So a mere thought without any following action is not punishable. But nevertheless, there are, however, some exceptions to this rule. When we talk about IPC and all, we'll come to know. Because if you see the hierarchy of the society, state stands at a higher pedestal, then comes the society, then comes the family, then of course last comes the individual, isn't it? Now, when public at large, that's what I told you in the very beginning of my lecture, that when public at large are affected, then that kind of an offence against the public is more serious in nature when compared to a crime that is being committed against the society or family, or for that matter individual will take a last priority. So if you want to grade an offence, whether it is as to whether it is serious offence or a minor offence, the only criteria that is laid down is how many people are getting affected. So public at large or state at stake, because state is representing a group of people who are all law abiding and then who follow rules and all. So when this population is getting affected, when their rights are going to be violated, or when their lives and liberties and properties are at stake, definitely it is the sovereign here, the state. The state takes the onus, responsibility of protecting the properties, lives and limbs of the members of the society. So that is the reason why we say more serious crime is one. Even mere thinking, we said mere thinking can never be punishable, but there are exceptions. I told you, if somebody is planning to topple the government, or somebody is trying to boost somebody who is in the political positions, or somebody is trying to do some anti-state activity. So the mere thinking, planning, that itself is, by itself is a crime. So such cases, treason and all, against state and all, these activities are very serious in nature, because when you say state, it represents the entire state. So that is the reason why such type of cases, such type of offences are given a position very high. That means in the hierarchy they stand at the top. So the second element, as I said, mental element. Now how to understand this mental element which is otherwise not visible? The act that follows is very much seen, that you are beating somebody, killing somebody or kidnapping somebody, that act is seen. But whereas the mental thought process that goes on in the mind of a person, nobody knows. But then how the IPC or Indian Penal Code, or that for that matter the Naya Kanun and all, new act and all with a different name, but then say it retains the structure, there is no change in the content, but only name nomenclature is little different, that's it. So there is a gradation and all, as I told you, depending upon the seriousness of the punishment and all. So there are different words that are used in order to know the mental thought process. They are using different words: fraudulently, dishonestly, isn't it, knowingly, intentionally. There are certain words. By looking at those words, we know the intent or the knowledge, whether he has knowledge of the consequences that happen after the act and all. So there are different words, phrases, with the help of which we will understand that there is an intention, there is a mens rea, there is a dishonest element that goes on in his mind. So these things will definitely help us in understanding the mens rea, though not explicitly it is been explained, but then by using certain terminology. By using certain words and all, we'll come to know whether mens rea element is fulfilled in this particular act or not. Then these are two different elements. Now mens rea, as I told you, and actus reus, these are two very important elements of the crime if you have to define a crime. So mens rea is, as I told you, guilty mind. I mean, it should accompany the act will be accompanied only when you have design of some thought process. You have already designed that thought process, you are going to implement it. How are you going to implement? Some muscle movement, some activity, isn't it? So when both these things are there, only then it can culminate in a complete crime. So the first element being mens rea, as I told you, it is a guilty mind, and almost all crimes have some mental element. It is only the degree that varies, isn't it? It is only the degree that it varies. As I told you already, there are certain words that are being used in the definition clauses of Indian Penal Code. The common words that you find in any of the acts in most of the sections is the word intent, knowledge, rashness, recklessness, reason to believe, fraudulent, dishonest, corruptly, omitting, maliciously, deliberately, voluntarily. So these are different words and phrases that are used in most of the sections of IPC, with which we can only understand that the element of mens rea or mental element is very much present. So that is the guilty. That's how you have to gauge the guilty mind. And when it comes to actus reus, that is the act that follows guilty act, it consists of physical actions. As I told you, some muscle movement. For committing a murder, for example, one has to take out a knife and then bring it to the, I mean, he should know some anatomy of the person and which spot he has to put his which part has to be pierced by this dagger or weapon or knife or whatever, so that there is a sure sign of death and all. So there must be some muscle movement, some activity, some movement of some part of the body has to be there. So as I told you, not all actions are punishable. There are certain actions, acts which are specifically, explicitly being prohibited by law. Only those actions are punishable. So for example, actus reus in case of theft, that means the theft, there should be some movement of the movable property from the owner to, he will be dispossessed of that and somebody will be taking. So there is an act of removal of property from one person and to be taken by the other person. So like that, in all property offences, whether it be theft, extortion, or bribery, these are some kinds of property offences. Suppose murder, then assault and cruelty, these are some kind of bodily offences. So what I mean to say is, there should be some act. You have already mental framework to do this, and you have already designed, you have planned, you have purchased some weapon or you have purchased some firearm, so that in case if there is some resistance, you can make use of that and threaten people, put them under fear or threat of fear, and then whatever valuable you want to take away, you can take away. So there should be some muscle movement, some activity which should follow always the mens rea. So both together, if they are occurring, then we call it as a crime. So every crime has got two elements, and if you have to establish the commission of a crime and then make somebody guilty, all that you have to do is you need to establish these two elements and then establish the elements and then prove the case and then put him, if the crime is proved with all the evidences successfully by the prosecution, definitely the case will end in conviction. Otherwise, as I told you, benefit of doubt goes to the accused, and it will result in his acquittal. Am I clear about these things, or is there anybody who is not able to understand this? Am I clear?
Yes, ma'am.
If at any point of time, as I have already told you, any point of time, anybody not clear about any concept, because after all it is little abstract subject, unless until you pay attention and understand each word, it will be otherwise difficult. So, as I told you, there is a gradation. Menseria can be graded. I mean, not in all crimes you will have the same quantity or quantum of menseria. So, how it has to be understood. Now, there are different words, as I told you, which are mentioned. It is called the intention, transferred intention, knowledge. Now, each one of them, let us try to understand. Now, Indian Penal Code also, I mean, it deals with these bad or guilty intentions of human beings by the usage of the words, as I told you, intentionally, voluntarily, willfully, deliberately. These are the words that are used specifically in some sections to understand the menseria. Now, intention means a desired objective or desire to achieve certain purpose. So, there is a strong desire to achieve a particular purpose. Now, that forms the basis, and that is the intention. So, now sometimes deleterious for other human beings. I mean, whatever you intend to desire, it is not for the good of the other person. It is always going to the consequence of your desire is going to end in some action which is harmful to the other human being. So, or it may be a single individual, or at times it may be society at large, public at large. So, whatever act that you are doing, whatever thought process you are having, whatever intentions you have, whatever desire you want to achieve, if that is going to harm or that is going to be deleterious to the human being as an individual, or if it is going to harm the entire society at large, definitely that intention we say is stronger, and that gets reflected in the definitions by usage of the words called intentionally, voluntarily, willfully or deliberately. Now, what is transferred intention? Now, A intends to murder X. For achieving this object, A mixes poison in X's food and places it on A's table. Now, we will try to understand, there is no direct intention, isn't it? There is no direct act here. Now, what he intends to do is, he wants to murder, but then he doesn't want, he doesn't go with a weapon and then try to attack him and then try to, cause some injuries, and then out of that injuries, out of septicemia, and let that person die. It may not be that kind of a strong intention. What he does is, ultimately he wants to murder the other person. So he can achieve this particular objective intention by mixing, whatever food that is going to be given to X, he ensures that some poison is mixed and then it will be given to him. So he is definitely, when he is hungry, he is definitely will have his food. So, however, by feeling unusually hungry, raids X's lunch and dies. Eats X's, not raids. So, what he does here is, there is a third person. The intended person is Mr. X, isn't it? He wants to kill X, but then he never anticipates this. He only knows that regularly X is in the habit of, pouncing upon the plate and then eating voraciously and then trying to suppress his, his hunger and all. So what he does is, he is very sure, he 100% sure that A is going to have his lunch or dinner at a particular point of time, and then knowing that particular bag, he tries to mix some poison in his food, and then whatever is the normal place, he will take the food, he will arrange the food there, and then he is waiting for the person to have the meal and then die. But then it so happened that a third person, Y, happens to go there on the table. And then he also, that particular day, fateful day, he also felt so hungry that he started having that. Isn't it? Now, what is the liability? Criminal liability. If you want to attribute the criminal liability to A for Y's murder, because Y is not the intended person whom A wanted to kill, isn't it? Y is an unintended person. He is a third person. It happened out of accident though. But when you talk of liability of A for murdering Y, because A never intended to murder Y. His intention is to murder X, but then it so happened accidentally, he happens to go there and then he had that meal, and then not knowing that that meal is laced with poison and all, he will have it, and then in the, subsequently he dies. But when you talk of A's liability for the murder of Y, even though he did not intend it, because his intention is not to kill an innocent person like Y. He has some grudge against X and he wanted to finish him. But fate decided the other way. That is, Y accidentally happened to be there and then he was feeling very hungry that particular, unusually, he never, otherwise he can control hunger and all, but then on that fateful day it so happened that he happens to visit X's house and then there he saw on the table ready food, and then he had it, and then in the process, after consumption of that food, he dies. But then though A never intended to kill Y, but when we talk of criminal liability of A for killing Y or for murdering Y, we can say that it is definitely a murder, because that strong intention to kill somebody, that is there, and that also the consequence of that act also resulted in death of Y. Hence, when you say that liability of Y is transferred intention, intended to kill somebody, got killed somebody else. So, this is called transferred intention. So, A is definitely liable. So, whatever liability that he has got killing somebody, whether X or Y, under 302 or 301 IPC, the same liability will be there for A. So, accordingly, he will be tried for that offence, and if the in the trial, during trial, if the offence is proved by way of evidences, and if the prosecution is successful in proving the guilt of the person, definitely guilt is proved, and then accordingly punishment will be levied, and he will be put either behind bars or fine or whatever the section or track, that kind of punishment can be given to him. So this is intention, transferred intention. Now there is another element with which we can grade mens rea is knowledge. So knowledge, if you want to define, knowledge is the awareness of the consequences of any act or omission. So I have full knowledge. That means this is a wrong thing I am doing. If I do this, I will either harm or it may be deleterious to somebody. Somebody's health may be at jeopardy. Somebody's property may be taken away and all. I have full knowledge. I know. I mean, the consequences of my act I am aware. So if I still do that act, then I am said to have the knowledge of that particular thing, act. So what should be the element of knowledge? Somebody should be aware that these are the consequences of an act. Each act has got a consequence, isn't it? If I know that if I do this particular act, this is going to be the consequence. If I am aware of that, then I am said to have the knowledge about that particular act. So a person is said to have the knowledge of a particular act only somebody knows what is the consequence. If I stab, somebody is going to die. If I shoot somebody with a firearm in point blank, the other person is definitely to die. Because I know the consequences. I know the consequence of my act, then that thing is called knowledge. So, if you want to take an example, a bus driver has knowledge that if he does not keep his eyes on the road while driving, an accident may ensue. even if he doesn't intend it. See this. So for knowledge, you need not be intending to do a harm. See, if I am negligent, then if I am not careful while I am driving, if I don't keep a vigilant eye on the road, then it may lead, the probability that accident will happen is 100%, isn't it? So that is knowledge. I know if I am negligent, that is if I am negligent, if I am not following the road rule, and if I am not controlling my speed. That is the act. What is the consequence of that? It is going to result in accident, isn't it? Now, that is prohibited. This particular act, negligence, is prohibited by the law. So an act, the consequence of which is, punishable, then even if I don't intend it, my intention is not to go with a speedy vehicle and hit everybody and kill in the process. That's not my intention at all. But then what is happening is, with my act, the consequence of which is going to be an act that results in harm or some deleterious effect to the other person, definitely that has to be, that should have a punishment, isn't it? An act which is prohibited by the law. So even though he doesn't have the intention, but then as a consequence of his action, that is negligence, at least some accident, if not killing people, at least some accident, some injury is going to be there for the pedestrian. So that way I am liable for that. Here the bus driver has knowledge, but may have no intention to commit an accident. So these two elements, that is the reason why we often see that these two phrases have different connotation, different meanings altogether. So intention may not be there, but then knowledge, if it is there, that is also sufficient for somebody to be punished, isn't it? Law also has a lot of provisions in it, whether knowledge is there, whether intention is there, how strong is the intention, whether somebody has got the knowledge and awareness that his act is going to be result in some evil consequences and all. The mere knowledge is also at times is sufficient. So that is the reason why intention, transferred intention, knowledge, there is a gradation of mens rea what you need to understand. Am I clear about intention, mens rea, transferred intention and knowledge with examples?
Yes, ma'am. Yes, ma'am.
Is everybody with me? You are able to understand? Because these are very basic things. Unless until you pay attention for this, unless until you clearly understand these definitions, it will be difficult as we progress. Understanding each section with its jargon and all is going to be little tougher. So initial stage only, if you are not able to cope up or not able to follow, you can always have the liberty of stopping me at any point and then seeking the clarification. I hope I am quite clear about these concepts. Should we go ahead? Yes. So again I said we have used the word negligence. We can understand negligence in two different kinds. So what is that? Advertent negligence, inadvertent negligence, isn't it? What is advertent negligence and then how is it different from inadvertent negligence? You have to understand by taking examples. The more examples you study, the concept becomes a little clearer. Advertent negligence or rashness or recklessness or willful negligence, isn't it? Rashness. So if you are going with a rashness and a negligent way, that will definitely end in some accident, isn't it? Advertent negligence is also known as a negligence where a risk is foreseen, yet the risk is undertaken foolishly by thinking no bad consequences shall result. See, here what you need to understand is, now if you are going with a high speed, if you are driving rashly, you are taking a lot of risk, isn't it? You are aware, you are a driver, regular driver, and you know how much speed you should go so that you can foresee that even if some accident is going to happen, you have full control on the vehicle, and then you know that if you apply brake at one particular point of time, you know that depending upon the speed of the vehicle, it is going to stop at one place, and then you can foresee beforehand, before the occurrence of the crime, you can see all that before the accident happens. You are fully aware that if I go with this speed, the brake is in my control, I can avoid accident by applying brake and all. It is known to you now. So, but then you want to take a risk. I am an experienced driver. What if I can control everything, and I am 5 years, since last 5-6 years I have been driving on the road in a very highly traffic road, and that too in the office hours. I know how to drive and all. If you are so overconfident and you are inviting risk, isn't it? Your risk is foreseen, yet you know that for sure if you go with this speed, even if you apply brake, even if you can foresee some accident, it is going to happen. There is nothing much that you can control, because the speed of the vehicle is so so much that even if you apply brake also, because of inertia and all, it takes little time, reaction time for you to apply brake, and then and immediately the vehicle will not come to standstill. It is going to the wheel gets locked, and then with the locked wheel and all, it is going to be dragged to some distance. Only then it is going to stop, isn't it? By that time, whatever harm has to happen, it would have happened, isn't it? That means I am taking high risk, high amount of risk, and then I am overconfident, where I am not supposed to take that kind of a risk, but still I undertake it. That means it is only foolish act. No sane person, or no person who has some prudence, some common sense and intelligence, would like to take that much risk. A risk should be commensurate to the challenge, isn't it? A risk which which I will not be able to take, and I am very sure that the consequence is going to be a failure. Why should I take such a risk? So it is a foolish act, isn't it? That is called the advertent negligence, or rashness, or recklessness, whatever it is. So, foolishly, by thinking no bad consequences, you are not a god, that though I take a risk, though I go with a high speed and all, yet I can control, all physical elements are in my control. So you cannot just predict anything, and you cannot expect that no bad consequences, or God is always with me, He is so kind enough. So every time I go rash driving, I am protected, no accident has happened. This is all foolish and overconfidence, isn't it? So it is more of a overconfidence, and then with that overconfidence I take a lot of risk, and then ultimately whatever accident has to happen, luck will never favor every time, it only favors at times. So this is only a probability you are trying to take risk, that's it. It's a foolish act. That's what is advertent act, or advertent negligence. This is common in rash driving. If an accident ensues, the driver is liable for advertent negligence, or rashness, or recklessness, willful negligence, that you know the consequences, that this act will definitely lead me to some evil consequences. That particular knowledge is there with him. So knowledge of what the consequence is going to be, whether it is going to be evil consequence, or whether it is going to be good consequences, I already have foreseen knowledge, isn't it? Still I am taking risk. That means it is called willful negligence, or rash, or negligence, advertent negligence. So the expression advertent means avoidable. See, had I taken precaution initially to go with the controllable speed, I would have avoided the accident in all probability. But then I am now taking a high risk. I still go with a rash, I'll be rash in my driving, I still go with a high speed and all. These are all the risks I am inviting for myself, isn't it? Otherwise they are not warranted, isn't it? But then out of overconfidence I try to take risk, and then my expectation is that no bad or evil consequence is going to happen. But many occasions I also try to be very, rash and all, but I have never, in my lifetime, I have seen that some accident happening. So let me this time also take that kind of a risk. So that is the thing. Now, the expression advertent means avoidable. I could have avoided the accident had I been little careful, had I been not so reckless and all. I mean, that is what is avoidable. Advertent means avoidable. The person knows he can avoid this conduct, be refraining from it. Let me not do it. When I have to take a risk, when I am going at a high speed, I am definitely going to end up in some accident. So let me refrain from it. Let me not do that. That is what it is avoidable. But still I am taking risk and then I am not avoiding that. I am inviting it rather. So yet he goes along to bear the risk in a devil way, may care attitude, may not care attitude. This is known as advertent negligence. So the consequences are known to me. The consequences of my act are very much in my knowledge, but still, what is that I am trying to do? I am trying to take a lot of risk, which otherwise could have been avoided. Risk is not always advisable, isn't it? I could have avoided that risk. So, though it is avoidable, yet I am trying to take that risk, and then I am inviting trouble for myself, thinking with overconfidence that my rash driving may not end up in some accident and all. This is what is known as willful negligence or avoidable negligence, and this is also called as recklessness. And the best example I have already given is driving, because truck drivers also, they one thing is they will be tired because throughout day they will be, the more trips, the more money. So, and more so when the trip is undertaken during nights and all, there is no traffic or minimum traffic on the road. So, the material can be delivered within no time. So, they have these weaknesses, and then with overconfidence, so they try to drive on the roads, and then most of the time we see that especially in the outskirts and all, thinking that there will not be traffic, and then they don't mind giving warning signals also, and then ultimately that is going to end in some willful negligence. Now, inadvertent negligence, you don't intend. It means inadvertent is, you don't intend that, and then it is opposite to advertent, isn't it? Absence of duty to take care and due precaution. So this is, you are supposed to take some due diligence, some due precaution, and then carefully it has to be done. A particular thing or a particular operation or a particular activity has to be undertaken with all care and then due precautions. Some precautions have to be observed and all. You know that, but yet if that element is absent, then that is called inadvertent negligence. Example is, doctor who leaves the scissors inside the patient's wound is liable for simple negligence because he did not have knowledge of them being inside when he sewed the wound. There are other duty doctors also. Whenever a big operation kind of a thing is there, it is a team of doctors who do the operation, and then the main surgeon will be attending on the stitching and all, and the other helping assistant duty doctors, it is their job to see that all implements are implement that are used in the operation are properly been sterilized, properly been removed, properly put at their places and all. It is the duty of the duty doctor who is attending on the patient. It is or the person who is going to be operated. It is entirely their duty. But believing them, thinking that they have taken due care and all, and he stitches, and then without knowing that there is one implement, namely scissor, inside the body. So neither intention is there nor knowledge is there in this particular case. So such type of negligence are called inadvertent. In the first case, there is knowledge. That means knowledge is nothing but when somebody knows what is the consequence of the act that they are doing, and if that consequence is going to be evil or bad, then we say knowledge is there for that person. Now, in this particular category of negligence, which is called inadvertent negligence, neither knowledge is there nor intention is there. So, no doctor intentionally would like to kill a patient. It is against the ethics of doctor. nor he has knowledge that some implement is still inside, but he has good faith. He thought his assistant has taken due diligence, due care to remove all the instruments from the body of the patient, and then now everything is okay. Now he stitches, thinking that everything is fine, and then the operation is successful, and all. To his utter surprise, maybe it is inside, he has no knowledge about it, and neither he has intention to kill patient by putting an implement inside the body and all. So this is talking about both your knowledge and also the intention. Both of them are lacking in inadvertent negligence. Am I clear about negligence and the category of negligence, advertent and inadvertent? Yes?
Yes, ma'am.
हाँ
Yes, ma'am.
ठीक है. So others are remaining. I could only hear few voices, but then other voices also they need to be vocal. So such platforms, it will be difficult for me to call everybody by name and then ensure that everybody has understood or not. It is your own as a responsibility to react, and if some point is not clear, it is from your side, you have to tell me so that it can be explained once again. Presuming that everybody understood this concept, I am moving ahead with the slides. Now, motive is something different. We have studied so far intention, knowledge and motive. Any crime to happen, there should be some motive. Without any motive, somebody is he bent upon killing everybody, whosoever he meets in the street. If he goes on killing without any motive, without any intention, we call such people as madcaps, isn't it? Insane, not sane. So, but somebody should have a motive, and we should not confuse motive with mentality. It hasn't moved. I am showing the slide as motive. Motive is not seen.
You've seen. Motive.
Yes, ma'am, that is visible.
Yes,
But why this gentleman who is saying that it is not moving? Maybe क्या है? You have just joined or what is it? You have put it on and you are attending to some other work? You have internet issues. You have to check from your side also, not pointing finger only to one person. You should also check twice before you say something, Because I also have lot of internet issues, but then I keep plan B, plan C, plan D, so many alternative plans I keep. Because I cannot take a plea under the guise that, no internet, I can't teach. Probably students can take such pleas. As a teacher, as a speaker, I can't, I am not at liberty to take pleas, though I have issues. Okay? So motive, we should never confuse it with menseria. See, what is the difference between motive and menseria also we have to at times understand. Motive is, it is a kind of a prompt, a man to form an intention. So the basic thing is you should have an intention. What is the basic thing that prompts you to form an intention? That is, intention, the motive is much more before the intention is formed. It is a drive, it is a desire that prompts a particular individual to form an intention, isn't it? That is motive. Motive is not an essential element of crime. That is the reason that whenever we define crime, we are concerned only with two very basic essential elements, that is mens rea and then actus reus. But then prior to forming a mens rea, there is again another element. When intention is the element. Now, there should be some kind of a drive, some kind of a urge that makes a man to form an intention. Is that particular urge or that particular kind of a design which prompts a person to have an intention is what is motive. So that is the reason why in the definition of a crime, it is not forming the essential element of the crime. So you need not prove a motive. All that you have to prove in a a criminal proceeding to prove the guilt or otherwise of a person is, all that you have to do is only prove these two elements of the crime. That is, one is your mens rea, the other one is only the actus reus. So for a thing to take the shape of a mens rea, there are other prayer steps also. There are previous steps also that are there. So motive is one such step, which is rather a desire which is prompting you, which is motivating you to do a particular, to form an intention, to form an ill feeling, some thought process. So that is called the motive. So hence it is not a part and parcel of your definition, and motive, however, is relevant under evidence side, because in order to prove mens rea has to be proved in a different indirect way. So for that you have to prove the motive also. Indirectly it is there. So under Evidence Act it also becomes very important. I have no motive, no desire, but yet I am killing somebody. Then there should be some kind of a logic that is missing. If you don't prove motive, you will not be able to successfully establish the mens rea for that crime. So hence motive is also important, though it is not a part of definition of crime, yet for evidence purpose, for Evidence Act purpose, it is also to be kept in mind by the investigating officer to prove motive also. So example here is, when once one feels hungry, the motive is to satisfy hunger by eating, isn't it? So there is a motive. So why are you eating? You are feeling hungry. The motive is, why are you feeling hungry? That is, you have to satisfy your hunger, and then how can you achieve it? By eating, isn't it? So there is some motive, and in order to achieve that motive, in order to take it forward, it has to transform itself into intention, and when intention is there, then an act also is there, and both of them are leading to some consequence which is evil in nature. Definitely it forms a crime. Now, whereas intention may be to steal bread if one doesn't have money to pay it. See, understand that intention versus the motive, isn't it? Now, I can satisfy my hunger by legal means, also by illegal means. I can earn money, I can do some hard work, seek my livelihood, and then I can also buy things in a legal way and legal means, and then also satisfy hunger. That is one way of doing. But I want shortcuts for that. So I don't have money. But money, non-availability of money will not stop my or satisfy my hunger. So I have to somehow satisfy my hunger. I don't have money. But in some movies and all, it is quite common that people try to. So for the first time, he was not caught while he was taking away bread. But then while he was trying to keep it back, then he was caught. But then that motive is there, that drive is there. So that is the difference between motive and intention. So intention may be wrong, isn't it? See, motive is driving you. What is the motive? You are feeling hungry. Now, how will you achieve? There are two ways. Either you earn money, tender that change, buy that, and then eat it. That is one way of doing. But I am poor. I don't have money. I am not intending to do some hard work also. My hunger is so motivating me that immediately if I don't eat anything, I may die. That is the feeling I have. So what do I do? By somehow, by hook or crook, I have to satisfy my hunger. So in the process, my intention is somehow steal bread, because I am so hungry that I will steal the bread and then I will satisfy my hunger. So doesn't have money to pay for it. This is the difference between the motive and an intention. How you achieve that, by legal means or illegal means, is what that matters. Am I clear about motive and intention? Motive is the driving factor. In order to form an intention, there should be a prayer step called a motive that drives you to form an intention. Intention will not be formed in one day, or it will not culminate as such, it will not be there. But prior to that there has to be some desire, some motive, some drive to form the intention. Am I clear about this?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
I think we'll stop at this point. Probably in the next class we'll go ahead with other definitions and then the consequences, causes, the theories, and then the punishments, and then the types of crimes and all. I think all in the rest of the things in the next class probably. So I have already shared this PowerPoint. It is very much with you. So before you come, please come prepared, read, give a cursory look, read it. Even if you don't understand, just read it, try to understand. And anyway, in the classroom, will in the virtual classroom, will try to discuss each point. And if somebody not able to understand that, you are at liberty. You can always ask me. So, in absence of any doubts and in absence of any further queries and clarification, I deem that you all have understood that and you are following me. So, with this I think we can close the session for today, and tomorrow at the same time let us virtually meet.
Yes, ma'am.
Okay, ma'am. Thank
Right.
you so much, ma'am.
Right.
Thank you, ma'am. Thank you, ma'am.
Right.
Thank you, ma'am.
Okay.